on that language?
I have not contemplated that. I have tried to play it very straight on ballot issues. When a ballot issue is proposed, and of course at that point it would simply be a matter of starting petition gathering. It's not clear that it would appear on the ballot necessarily. I have tried to respect my role as Attorney General. The one that gave me a little bit of problem was the Veteran Service Bonus Amendment last year, because as you'll recall, I had initiated that when I was treasurer. I was well on record. I testified in both houses on it. Again, I attempted to avoid encouraging anyone to vote for the measure, as opposed to playing my role straight. Although I certainly couldn't unring the bell on that when everybody knew that I was for it and pushed hard for it to get that through the legislature and put it on the ballot. But it is not my role, as I see it, to try to influence a constitutional amendment process that's put in front of the people of the state of Ohio. And I think it's very important for me in various respects in this office to try to separate any personal views I might have from my role as the chief law officer for the state of Ohio. I've tried hard to do that. I'm sure people could disagree at times whether I've succeeded in that, but I do try hard to do that.
What would happen if somebody would file a formal request for a legal opinion from your office on the constitutionality of that amendment?
Typically, it has been the response of this office when asked for formal opinions by public officials who have the authority to request those formal opinions on the constitutionality of a measure to decline to offer an opinion, because in the end we would potentially have the role that you mentioned earlier if something is challenged in court of having to defend that measure, whether I personally disagree with it or not, unless it had absolutely no colorable merit whatsoever. And in that case, it would be a hard question. Do I offer no defense? Do I go to my clients and talk to them and see if we have consensus? But typically, since I would have to defend measures, even that may be a very questionable constitutionality, we don't opine on that, because that would lock in. It would certainly not be helpful in litigation if I'd rendered opinion questioning the constitutionality, now is defending the constitutionality, right? So that has been the custom and practice of this office going back many attorneys general over the years.
As I understand it, if you put a red light on that decision on Thursday, that would allow them to go straight to the Supreme Court.
I'm not sure what you mean, a red light.
Not authorizing the ballot language. Would allow them then to go to the state Supreme Court and let the state Supreme Court settle the issue up or down.
Well, I don't think that's correct. I believe my role on that submission is to determine whether the summary submitted with the measure is a fair and accurate summary of the measure. If I were to decline to approve it, it would be on that basis. They could then go to the Ohio Supreme Court and challenge my determination that that summary is not fair and accurate. It wouldn't be a determination of whether the measure itself has constitutional validity or not. It would be a different matter. So I don't think it's fair to say that that would be an issue in the case, although it would be up to the Ohio Supreme Court how they wanted to frame those issues.
How different are the issues when it comes to that ballot issue and the sovereign immunity ballot issues that your office has rejected, I think, twice already?
Well, they're all different. I mean, in each case we get a submission that lays out a measure that people propose to have adopted into the Ohio Constitution, and that may be, in those cases, quite voluminous. And then we also get, by law, we're supposed to get a summary of the measure, that will, understanding that when you go out to get petitions signed, people aren't typically going to take the time to read a voluminous measure of several pages and thousands of words. So they are to be presented with a summary so they can make a judgment more quickly on the spot. Do they want to sign this or not want to sign this? Okay. So the point of the summary, it becomes quite crucial. Is it a fair and accurate account of the larger measure? If it isn't, then it would be misleading to put that summary in front of people and ask them to sign when in fact the measure does something quite different, right? So that's my role, is to determine that. Those submissions, and I think we've been presented with it and rejected 3 times, each time trying to explain to them why it's not close to a fair and accurate account. In each case gives an opportunity to go back and cure that. They have not yet managed to do so.